Welcome to our webinar series. We will be inviting experts from a variety of sectors to share with us their expertise and to provide us with new insights on the market they are specialised in. My name is Eliza Rayner. I am Business Development Executive at Affinity Group, and we provide corporate structuring in the Isle of Man, Malta and Cayman Islands. In this webinar, we will be discussing the intellectual property sector, and we will discover why it is so important to form an effective strategy for IP monetisation. We will cover the key points to consider, including IP structuring and licensing. A company's intellectual property is a very valuable asset and can significantly contribute to a company's competitiveness and long-term growth. We have invited two experts to discuss this topic today, and we are joined by David Holt, partner at Potter Clarkson, and Matthew Galia de Bono, partner at GD Advocates. We will start with the introductions.
Yeah, no problem. I'm David Holt. I'm partner at an intellectual property firm in the UK. We're Anglo-Nordic, so work across the UK and into Scandinavia as well. Do a mix of work, but predominantly around IP licensing, strategy, research and development, and collaborations. So a lot of expertise in terms of commercializing novel inventions across Europe and elsewhere globally.
Great, thanks. Thanks, David. And yourself, Matthew?
I'm Dr. Matthew Galia de Bono. I'm a Maltese lawyer. I work in a boutique law firm based in Malta, where we mainly offer services in relation to information technology law and intellectual property law.
Fabulous. Okay, thank you both. If we're ready to proceed, I will just be asking you a series of questions to cover the topic, and if you could both just provide some of your thoughts and feedback on these questions. So initially, the first question is, how does intellectual property contribute to a company's competitiveness, growth, and innovation? And can you share with us some real life examples?
Yeah, definitely. So just to sort of start off with this one, I think it's obviously a core part of any real innovative business's lifeblood, to be honest. The thing about intellectual property is that it's a permissible monopoly. It allows a company to hold its own space around products, services, inventions, and brand, which basically allows an element of exclusivity to exploit in the territories in which they're protected. So it's a bit of a state bargain. The exploitation of that monopoly is then intended to provide revenue, and that's the exchange for example, filing a patent, assist the public in developing their knowledge in exchange for a financial reward for that innovation and investment in the first place. I think the interesting thing about it is that the goal is to encourage further investment in innovation, so to create innovation cycles. So that leads to additional research and development opportunities, it leads to growth, and it leads to greater employment as well. So a lot of what you see publicized is some of the negative things about intellectual property, companies falling out and people having proprietary protections over medicines and things of that nature. And I think that's the minority. The majority of it is creating a business plan which also comes with a level of security. So the intellectual property backs up your commercial goals. So I think some of the famous examples you'll have seen in terms of protecting a company's own competitiveness, some good stories and some bad stories. You've got Lidl's trademark win in the UK against Tesco, which was a really interesting one from a trademark perspective, the yellow and blue combination, and Lidl successfully demonstrating that Tesco was seeking to take advantage of their reputation by using that colour combination. And then you've also got M&S winning against Aldi eventually in relation to the Christmas and festive gin products. So it's a very clever use of design rights to make sure that Aldi wasn't able to piggyback on M&S's success with their festive gin. So M&S being quite a substantially smaller party there. So it does allow you to protect yourself as a business.
Great, thank you.
I think what I would add to what David said, which I think very much covers the whole question very succinctly, is that it all comes down to goodwill. Basically, with intellectual property, you are protecting your goodwill on the market very often. That's primarily the case for trademarks, but to a lesser degree, analogously so, also in the cases of other things such as copyright, patent, or design rights. Because basically, your intellectual property represents your identity on the market.
Yes. And it's obviously quite clear that this is very important for companies, whatever size, really, as it's your identity in the market.
I think it can be quite easily forgotten. I think there's a number of scenarios where people think, oh, intellectual property is not a key thing, even if you're trading on a business to business basis. Some companies think, oh, it's only if consumers are the people that I'm aiming my services at, then I need to care a lot about trademarks. But anyone will tell you there's recognizable brands, in our space as well as all other sort of service industries. When you're working on a business to business basis, you want a name and an identity that people recognize. As Matthew said, it's what carries that goodwill.
I can give examples of that. For example, in the iGaming sphere, where it's very common for intellectual property in the form of software to be licensed to other operators within the same sphere, who rather than develop intellectual property, end up distributing that intellectual property to players who end up becoming the end consumers of the intellectual property. But over there, you have a very clear and very lucrative, most of the time, licensing regime.
Great, thank you. So next question. As an intangible asset, how do you view the monetization of intellectual property as a stable and profitable long-term strategy for a company? Please, can you provide some examples?
Yeah, of course. So I think it's all about making your IP work in the right way. I think one of the worst things is having IP that you either don't use or don't know how to use very well. I think that's a trap you can fall into, filing and protecting for the sake of it. So doing it with an application of brain and commerciality is always going to be critical. In terms of long-term management of IP, I think if you're looking at it as a long-term strategy rather than a short-term strategy, which is, they are very distinct in terms of how you use it, there's a need for things like licensing and franchising, which is also a form of licensing. And those can be a really effective way of running a business, provided the product's appealing and the relationships are well managed. And those can give really, really long-term revenue streams.
Mm-hmm.
You can develop and sell your own proprietary products, or offer proprietary services, again, under your brand and using confidential information, which I consider a form of intellectual property, or patented techniques and technologies that underpin some of the most successful businesses on the planet, frankly. So there's a lot of good examples of that working with the security of IP around it. I mean, if you had Nike, for example, trading without any form of IP protection, you very quickly have other people looking to do what they do, creating lookalikes and very quickly diminishing exclusivity, and their market share and success would be harmed as a result. I think McDonald's is a great one. People trot it out a lot, but it's franchising. I mean, the McDonald's business really is an IP and know-how business alongside a property business. It's not really a food business in the traditional sense. The way they make the money is out of the brand itself and the supply chain and the property that goes with it. So, I mean, that in and of itself, if you wanted to cite one example, that would be a great one, I think.
Yeah, that's a great example.
I think what it comes down to is two things. Primarily, the protection of the intellectual property itself and the licensing of that intellectual property. The revenue stream primarily comes then from the way one licenses it, as David mentioned very well. Franchising is one way of doing it. In the case of software, licensing it out can be your entire business model, where you create proprietary software and then license it out, for example, an HR suite or an accounting suite, and then basically farm that out to customers in order for them to pay a license fee in order to use your intellectual property to their commercial benefits.
Great, thanks, Matthew. So what are some of the key methods for monetizing a company's intellectual property, and how can businesses determine the best approach for their unique situation?
Yeah, it's a really interesting question, I think, and it's again, when we advise on these things, we try and look at the business plan fundamentally, because a lot of this is going to be based on what the assets and resources and capability of the business are at the time. And I think being alive to that is always going to help the business find the right scenario. So things we talk about in the novel sort of therapeutic space is the amount of revenue capital that's needed in order to get through clinical trials, for example. So if you're a small business that has a fantastic idea and has protected it extremely well, you know there's going to be a huge amount of capital needed to get to the next step. So how you then choose to go about that, it will hopefully define your business model going forward. So you can exploit yourself, but again, how do you get the money in order to do that? You can license it out to third parties, in which case quite often you're letting go of the initial invention. And depending on the nature of your business, whether you're constantly innovating, whether this is kind of your blockbuster, you might not want to let it go completely. So you can think about things like collaborations. So you can monetize through collaboration by providing your expertise and your IP, but also receive a revenue stream up front for effectively sharing out the tail of the benefit with another party or multiple parties, depending on what's necessary. I mean, I think in particular, actually, the gaming space is a fascinating one, and the online space. I think Matthew might have some other interesting opportunities that pop up and have popped up recently.
What I've seen in my personal experience is that intellectual property in software is a very pervasive business model in our day and age, not just in gaming, but in other areas as well. Several clients which I've serviced are actually full-time software houses, and they basically work full-time to create software as an intellectual property, as a bespoke service, and then license it out to their customers. The result is creating a lot of intellectual property which is susceptible to protection, and at the same time is very profitable to license out.
So when you license out, I'm guessing there are various different routes to licensing. It depends on like the level of control that you want to hand over, essentially.
In my experience, licensing is primarily providing use for a royalty or a license fee. It's never actually giving over full ownership or control over the intellectual property. That would be assignment in legal
Okay.
terms.
Right.
At least it would be under Maltese law. David can correct me on that from his end.
No, I agree. I think that's a universal thing. I think that's absolutely the case, and I think control is a very interesting point. Full legal control almost always will remain with you, unless again you assign it over, which is a rare circumstance. But levels of exclusivity, the number of people you have in a specific territory, who's allowed to use your IP. There are different methodologies of creating competition even within a certain territory. So you may have 2 or 3 different providers or even sellers of your software, depending on the model, in the same area, and you want them to compete against each other. Exactly. So your network can be very large, which is slightly more, as you say, hands off, because you have to kind of trust people further down the network, because very unlikely you've got the headcount to manage every single individual relationship in that chain. But it is very much up to you in terms of how you do it.
Great. So what are the key factors to consider when forming an effective IP strategy, and how can a company balance maximizing returns and minimizing risks?
Matthew, do you want to start on that one?
I'll leave that one to you.
It's a good one, isn't it? I think it's a really interesting one. We talk about scope quite a lot. We've had some recent examples, because we do things from a due diligence perspective as well. So sort of from an investor side, or whether it's an individual or a company or even a collaborator, and things we look at in terms of IP strategies of younger companies and even more mature companies is part of it is the appetite for risk. Sometimes it's quite high and they protect things in a certain way, or they have a light touch IP strategy. Others are a bit more full on in terms of what they choose to protect, but each of those has their own benefits and burdens. I mean, we've had examples where people have spent £500,000 on IP over the next 2 or 3 years of their business plan without actually generating any revenue yet, and they've done that with funding money. Now that's a big hole in your overall bottom line if it's then not exploited effectively. So over patenting, over protecting is potentially as dangerous as under protecting. So we look at what territories are you operating in? Where do you need to access? Where are your suppliers? Where are your customers? If you're having things manufactured, for example, by a third party, do you have protection there? It's about understanding your network and where you're likely to be active, and you want to be selective with that. You don't want to just go, I want every country in the world, because there are 100 plus countries that you can access with a patent, and the bill on an annual basis would be enormous. It'd be in the millions. So you'd want to avoid that, really. Be aware of your third party rights. Again, knowing what's out there in the landscape, having a bit of an idea what your competitors are doing, what products they have, where they're protecting themselves. So if you've got a big US competitor and they've got a load of patent protection over there, but they've actually got nothing in Europe because it's not of interest, watching people and helping people patent strategically or protecting strategically around those territorial constraints based on freedom to operate is really helpful as well. And then sort of going back to commercial factors, look at how strong and relevant your applications are. Are your branding protections through trademarks or otherwise on point? Do they relate to what you're actually using in the market? Are they in the right scope of goods and services? Do they cover what you actually do? Avoid the Sky issue where they basically tried to file for everything, including whips and saddles, I think, at one point, which all got knocked out later. But you need to be tailored, because every time you expand the scope, you obviously also increase the costs. So be specific and make sure it's what you need, and get advice early on making sure you protect it sensibly. So those are kind of the things that we're looking for, and then thinking about that as to what are we doing as a business in the next 5 years, and how do we protect ourselves accordingly, and make sure those things marry up.
Well, one thing which David mentioned, which I think merits a little bit of emphasis, is the issue of funding, especially nowadays in a modern landscape where investment is taking certain new forms, such as crowdfunding. Obviously, when you're dealing with a few angel investors and you have a very clear brief as to how to use the invested money, it's one thing. It's quite another when you use crowdfunding platforms such as Kickstarter or Indiegogo. And there have been, unfortunately, many tragedies in terms of funding for creation of intellectual properties over the last 15 years, I think it's been. I can think of one which was a video game which was titled Project Phoenix, which looked to have a dream team of Japanese developers. They, within less than 30 days, racked up several million in funding, and within a year, the entire project just disappeared. It's not even clear to the public what happened to the money that was brought in. So these disasters do tend to happen. There does need to be a lot of discernment from an investor side as well, with regards to what projects to back.
Yeah, I think it's quite clear from your responses that it's wise to seek professional advice when forming an IP strategy, because there's a lot of elements that go into it, and if you've got, like you said, this capital available, that it's wise to have a long-term plan and map out all these different elements. Great. So next question. When advising clients on structuring their IP, which jurisdictions would you typically recommend and why? Can you also discuss the benefits of Malta as an EU gateway?
Sure. I think in terms of overall position, in terms of sort of strategy, I look at it from a sort of a litigation and sort of enforcement perspective, partially. I think Matthew's definitely going to be the expert on the Maltese gateway side, but I think enforceability is important. There's a very close annex between the owner of IP and the way that it's then protected through litigation. So when you have things like licensing structures, you can have licensees, including people within your own group, being responsible for enforcing, and if the case is that there are infringers in a particular territory and they want to stop them. However, certainly from an English perspective, and I think it carries into sort of general European enforcement as well, you have to demonstrate that you as a claimant have actually suffered some losses in order to obtain damages. So if you're holding IP in a position where you as the owner and you're responsible for enforcing, but you've actually not suffered any loss because you've received all the licensing revenue that you're expecting to achieve, and it's basically only your downstream licensees that are suffering, you might find yourself in a bit of a gap of not being able to enforce on behalf of those people who have taken a license from you, even if it's your own group members. So when you're planning carefully, you need to look at things like enforcement. You need to look at things like what revenue streams are coming in, where might I face a threat, where do I want to be able to say, yes, I've got standing to bring an action in a jurisdiction. So I think one side is the sort of tax side and the benefits of that, but also you need to think about how you're going to use it and then building up a structure around it. You can make it work, but it becomes more complicated the further removed you are from the territories of interest, generally speaking.
What I can add about Malta specifically is that we have a tax structure and regime locally where if a company is deriving its main revenue stream from licensing of intellectual property, it stands to receive a 6 out of 7 rebates on its corporate tax. So with a default tax of 35%, the rebate will reduce it to an effective 5%.
Yeah.
So that would be, but obviously I'm biased. My reason for suggesting Malta as a staging ground from which to hold intellectual property within companies.
Yeah, I think Malta's definitely got those efficient regimes in place, doesn't it? So there's some attractive benefits there. So that's definitely a jurisdiction to consider. So next question. Would you recommend IP licensing as an effective strategy for breaking into new markets?
Yeah, I think it's one where you want to make sure that you're doing it the right way. Make sure you're doing it in accordance with your business plan. But there are a number of benefits, including minimizing the risks that you bear. You can take advantage of local knowledge of the people you're licensing to, and potentially even the skill sets of the licensee on the receiving end. If they have better sophistication within the market, if they are more familiar with perhaps the way that your product is applied or used in the relevant territory, all of that is extremely helpful. And you can avoid issues like exclusivity if you choose to do so and if you have the negotiating power, because I think there's assumptions sometimes with businesses where what they say is, oh well, I don't really want to license because then I can't license to anyone else. I think there's an assumption sometimes that a license has to be exclusive in order to be granted or even vaguely appealing to a particular licensee, but that's not always the case, really.
No, as David is very correctly saying, I mean, licensing does not necessarily have to be something exclusive. There is a concept that we mentioned earlier in the webinar called sub-licensing, where you can actually allow, and it's usually done, for example, in the case of agents, where you would license to an agent who would then sub-license your intellectual property and create a chain of profitability that goes up a ladder all the way to the original owner of the IP. So to give an example, I would have an accounting suite software. I would engage somebody as an agent within the territory in which I want to market it. They bring with them the know-how and the understanding of the local market, as well as the culture, which may lead to a better distribution of the IP. And then what they bring in terms of profits and license fees will then trickle back to me as the original owner.
Yeah, that's great. It seems like that's a really effective way of breaking into new markets, as you've got people there who have the knowledge and know-how to work in the market, and you're also adding another avenue for monetization. So great. So how do IP monetization strategies differ in creative industries? And can you provide some examples of companies or individuals successfully leveraging their IP in these fields?
Yeah, I think the creative industry is a really exciting one at the moment, particularly with sort of Web3 and new ways of effectively taking creative works and looking to find new routes to market. I mean, I think when you look at things like Spotify and what that was able to do, in terms of getting it out to the masses really, and looking at revenue streams, we've gone another level really. So we've got non-fungible tokens, for example, are very much the in thing at the moment. You've got the use of NFTs in terms of album releases. So I think Kings of Leon were one of the first bands to do that, finding a new way of releasing effectively exclusive content to their followers. And I think in the clothing space, you have, companies like Nike are sort of leading the charge on this. They're creating, online garments and online sort of costumes for avatars and things of that nature, and using NFTs for that as well. And I think there's also a concept where you can sort of design your own purely custom shoe, for example, and you can have that as effectively encapsulated within an NFT. You can trade that if you want to, but it also gives you the right to go and actually have that made as a one-off item in real life off the back of having bought that in the first place. So I think people are finding really interesting ways of effectively protecting sort of unique creations. The blockchain is obviously extremely helpful as a record of when something was created, and it gives a sort of form of certification that we weren't able to get before. And I think that, in combination with sort of meta marketplaces, are going to be huge business. I mean, we work with a few clients who operate within sort of MMO type games and offer the facilities for server owners and creators to effectively offer custom content, upgrades and modifications, aesthetic ones mostly, for games, which is a huge revenue business now that was sort of not really in existence 10-15 years ago.
Definitely in the gaming space, it's become a very big thing. I mean, you actually have companies like Blizzard who are using Diablo 4 on an almost entirely aesthetics-based business model. Most of the monetization comes from custom skins, and we've been seeing that for years in the video game space with games like Fortnite, Call of Duty Modern Warfare, or even the other versions of Call of Duty. Now that I think about it, basically there's a growing market for cosmetic items within games, which form a very strong intellectual property, which quite ironically is purchased, but it's purchased in license, not so much in ownership. And this is something, in fact, which a lot of people don't immediately realize, that when you're buying these cosmetic items, you're not actually buying any sort of ownership over that item. What you're buying is a license to use that item while it's available.
No, it's really exciting actually. It seems like the as industries are evolving, so is the opportunity for IP. So that's great. Thank you so much for both participating. That was a really interesting discussion. Thank you for watching today's webinar. I hope you enjoyed the discussion and you took away some valuable insights on the intellectual property sector. If you're interested in seeking some professional advice, please feel free to contact David or Matthew, and they will provide you with more information on how to form an effective IP strategy. If you're interested in knowing more about intellectual property structuring, please feel free to contact us and we'd be delighted to assist you.